Well, on my watch, the time is 10 o'clock, so I'm now going to open the inquiry. Firstly, can everyone switch off their mobile phones, please, or set them onto silent? My name is Darren Hendley. I'm a Chartered Town Planner, and I've been appointed by the Secretary of State to hold this inquiry. The inquiry is into an appeal made by Rainier Developments Limited, Samuel Gray and Robert Clark under Section 78 of the Town and Country Planning Act 1990 against the decision of Braintree District Council. And that decision was to refuse planning permission for an outline planning application, some matters reserved, for the residential development of up to 37 dwellings, including 40% affordable housing, with vehicular access, areas of landscaping and public open space. And that's at land to the west of the A131 at High Garrett. Now, ordinarily, at this point in time, I'd ask for appearances from both the main parties. Obviously, I'm aware of emails that were submitted yesterday, particularly the appellant, in relation to how the inquiries should proceed, and particularly in relation to that it should proceed on a greater virtual basis than possibly was intended before yesterday. So I think firstly, before I move on to appearances and we kind of move on, I think firstly it would be useful for the appellant to explain to me what your current position is in relation to the inquiry and how it should proceed. And I presume would that be Mr. Easton, or what are you two gentlemen here?
No, so it will be me.
Okay, Mr. Easton. Yeah, yes, please,
yeah.
If you can start with your position, please. Yeah.
Thank you, sir. Well, can I make two introductory points? Firstly, a sincere apology for not being able to attend there. I'll explain in due course why I'm not there. Secondly, I'd like to express my gratitude for the council being able to so skillfully allow me to attend virtually today. That is much appreciated. So I'll just explain the detail. So on Friday evening, I attended an RTPI dinner. I had close contact with somebody who subsequently tested positive for coronavirus. I had a PCR test on Sunday, the results of which came back yesterday evening, and they were negative. However, speaking to, when I was trying to chase the test result on Monday, speaking to the coronavirus hotline, it was explained to me that if one is double vaccinated, it can take between 3 to 5 days for symptoms to show up and for you to test positive. So an exposure on Friday evening, leading to a test on Sunday, I was advised was too short a period of time. So I didn't feel that it was responsible for me to travel down to Essex to meet people in person, as it were, in circumstances where there was a risk that I would be carrying the virus. And just to explain the context, it was one of these events where, for some reason that's unknown to me, there was very loud music. The only way in which people could talk to each other was by shouting at each other. So I think the risk is relatively high that I was exposed. It doesn't necessarily mean that I'm going to get the virus. I feel relatively okay at the moment, but out of concern not to spread the virus if I was indeed infectious, that's why we took the decision that I wasn't going to travel down. So that's where we are at the moment, sir. Can I just check that you received an email that we directed to Leanne Palmer, the case officer, setting out what we considered would be an appropriate way forward?
Yes, I did, Mr. Easton. Do you want to run through that, please?
I would very happily, sir. So our starting point was to note that your post-conference note anticipated the possibility that people would need to attend virtually. And it's for that reason that the council very helpfully produced a Teams link, which I am speaking to you on at the moment, and indeed also the site notice, which we've considered does refer to the possibility to participate virtually. And it seems to us in the current climate that is a very sensible fallback option. So it seems that there are the possibility of people attending and participating virtually was always anticipated and made provision for. Our preference, our number one priority is to complete the inquiry this week and possibly into next week. Now, given that it's our position, or my position, that has led to the slightly unorthodox situation we're in, then naturally we're prepared to be as flexible as possible. Our preference, sir, would be to convert the entirety of the inquiry to a virtual inquiry of the nature that the planning inspectorate has so skillfully delivered over the last 18 months. So what we suggested in the email, and remains our position, is that we've opened the inquiry. That's in person, albeit with a hybrid element by me attending remotely. I have absolutely no difficulty at all in delivering my opening submissions this morning. Mr. Murray Cox, who thinks sits to your left, should have hard copies of them. I can deliver them. If there are any third parties there, so I'm afraid I can't tell from the screen, but I understand, I don't know whether any third party local residents who were originally scheduled to give evidence today are in attendance today. If they are, again, they can give evidence. I can hear what they say. If I have any questions, which I have to say is unlikely, I could ask them those questions remotely. So following which our preferred option will be to start with the housing roundtable tomorrow morning, again, entirely virtually, and then to run the rest of the inquiry as close to your programme, sir, as we possibly can, again, virtually. So there is sufficient time within the programme, in my judgment, to complete all of the evidence and closing submissions within the allotted time, even possibly by, well, I've spoken to Mr. Williams about this. I think our preference would be to finish the evidence by Friday, and if it were necessary to come back virtually next Tuesday to provide closing submissions, deal with conditions and Section 106 obligations, then that would still fit within the 6 days that's been allotted. In fact, we'd be within a day of the 6 days that had already been allotted. So that would be our preferred option. Another option, I suppose, would be to continue in the way that we are at the moment, as sort of a hybrid event. I mean, just finally, so what I should note is I've booked, given the incubation period, I have booked another PCR test for later on this afternoon, just to be absolutely sure. So that's our position, sir.
Mr. Williams, what's your views on this matter?
Thank you very much. I'm grateful to Mr. Easton for alerting us to the situation yesterday and keeping us up to date. 2 points, if I may. First of all, we don't consider it's appropriate to undertake the inquiry in the current hybrid scenario with the council team in person and the appellant team largely virtually, because that would give rise to practical issues, even notwithstanding the facilities we have here, but also a perception of an inequality of arms, i.e. a perception of unfairness. As to the appellant's suggestion of a fully virtual, if you were persuaded, sir, that that was consistent with fairness to third parties, we would certainly not object to that. And nor would I object actually to openings being provided today. I don't see there's any reason why that they've all been produced and we could provide those this morning.
Okay, thank you. I think it's probably, I guess, is a question maybe for the council first in terms of the logistics of how this would operate. Obviously, what I can see in front of me, there are no interested parties present, unless someone at the back is, no, there's no interested parties present. However, obviously the inquiry has been advertised as both, effectively.
So you should just have on your desk the start notice. To be absolutely clear, and I've taken a point about it, what it said is that, and you'll be able to see it, that it would run in person, and then, but if in exceptional circumstances, if people wanted to join virtually, they could do so and should register. Nobody has registered, to be clear.
The point I was going to make was that, I mean, obviously, obviously there's not an interested party here today, But obviously, conceivably, an interested party could turn up over the next few days and wish to question a witness. And they may be unaware, if the inquiry was changed, to be entirely virtual, then they would be unaware of that. And they may feel aggrieved at that circumstance. Now, what I was going to ask, if that situation arises, if a member of the public does turn up at council offices and wishes to do that, whether that facility would be available for them to come into a room, listen to the inquiry, and as per normal, when we go through the process of after cross-examination and so forth, the member of the public has the opportunity, if they wish, to ask the witness a question, like I do as the inspector, whether that is something which can be facilitated. So effectively they wouldn't be, if you like, prevented from engaging in that part of the inquiry.
Absolutely, so if I can take instructions on that, I think that's an eminently sensible idea. I was going to suggest, if you were minded to proceed virtually, that we could no doubt put a notice on our website to the effect. We could also have a note here to explain as much, but I think you're suggesting one further step, so which in effect we have a facility somewhere here where they could observe the inquiry virtually and, if necessary, participate virtually as well. If you give me 1 moment, sir, can I take instructions back? Very quick, so yes, we can do that. So.
Thank you. Just from my own viewpoint, I think the best way to proceed, listening to what's been said, and also the emails obviously I've read that were sent yesterday, is I'm happy after today for the inquiry to become virtual on that basis. On the basis, interested parties who do come to the council offices have the opportunity to, not just to listen, but also to engage at the appropriate moments in time. Now, in terms of where I would host the inquiry, if you like, I can't get a venue until Thursday to do that, to be aware. So unfortunately there won't be a possibility of the inquiry sitting tomorrow, in terms of going to virtual tomorrow, because obviously, as well as main parties and interested parties needing a venue for a virtual event, so does myself as an inspector. And arrangements are in place for me to have one of those, but that will be available on Thursday. So what obviously I'll see both councils' views on this. The way I'm minded to progress is that after we've finished this kind of mini case management conference, I will carry on with my opening remarks. Obviously, there aren't any interested parties to raise points, but I will give Mr. Easton an opportunity to respond to the written representation that was provided, which I'll go into in due course, from a member of the public who couldn't attend but who's made a written submission. So Mr. Easton will have the opportunity to respond to that. So after finish my opening remarks, we'll do the openings. We'll deal with that interested parties point, and then I'd also want to do the accompanied site visit today as well. I think that's a good way of making use of inquiry time rather than just having a half a day. Obviously, again, I'll move on to the arrangements for that, but as you'll be aware, it's simply a case really of pointing out things on the ground to me as a matter of fact. So there's an opportunity to put evidence to me. So at that point, I would adjourn the inquiry, and then we would resume at 9:30 on Thursday morning, and we'll start with the Housing and Land Supply Roundtable session. Any comments on that first?
That sounds sensible. So and certainly sensible to make use of good time today to do the accompanied site visit. We can discuss that in due course. It seems, if you're willing, so that we open today, it seems sensible we do that as well to make best use of time. We then have 4 days to get through everything, which I think is doable, sir, with a fair wind, because we'd have the Thursday, Friday, Tuesday, Wednesday of next week. If we'll see how it goes with a fair wind, I think we should be able to get through this evidence and the closings in that time. If necessary, closings may have to be in writing, but or we may have to come back on a separate day for closings. But we can address that if we get to that juncture.
And Mr. Easton, what's your views on my proposed way forward?
So it sounds eminently sensible, if I may say so, and we're extremely grateful that you've been so flexible in the circumstances.
Okay, thank you. Well, we'll proceed on that basis. Just in terms of a couple of kind of practical points, I will need the Teams link sent to my case officers. Obviously, I can enter the Teams meeting on Thursday. And in the event, obviously, members of the public do come to the council offices and come effectively listening or participate in the inquiry, I will also need an attendance list circulating on those days as well. And again, with that, on the end of each day, that should be then submitted to the case officer. Okay, Mr. Williams, before I move on, is there any further points in relation to the face-to-face and virtual matters that we've discussed that you'd want me to listen to?
No, sir. Thank you very much.
And Mr. Easton?
No, sir. Thank you very much indeed.
Okay. Thank you. Okay, I'm now going to move on to the appearances, and I shall take the names of those who wish to speak. So firstly, for the appellants, Mr. Easton.
Thank you, sir. My name is Jonathan Easton. Easton is spelled E-A-S-T-O-N. I'm a barrister instructed by Turley Planning. And so I have the following witnesses. First of all, Mr. Jonathan Dodd, who deals with housing and land supply matters. Then Matthew Grist, who deals with transport and accessibility. Mrs. Claire Brockhurst, who considers landscape character and visual amenity. And then David Murray Cox, who's with you in the inquiry room today, sir, who deals with planning policy and the planning balance. Can I just mention, this is principally, I think, for Mr. Williams's benefit, that Mrs. Brockhurst has availability issues on Friday. That doesn't cause a problem from our point of view, but it is likely I will call her before Mr. Grist. So Mr. Dodd will be dealing with the Housing and Supply Roundtable on Thursday. I'll then call Mrs. Brockhurst, followed by Mr. Grist, and then Mr. Murray Cox.
Can you just repeat that order, please, Mr. Easton? So just so I've got I'm sure my own mind the order of your witnesses.
Yeah, so Mr. Dodd will be dealing with housing and supply, so that's a roundtable session on Thursday morning. And then I will call, then we've got the council's evidence, but so far as my evidence is concerned, I've got three remaining witnesses. So I'll call Mrs. Brockhurst on landscape, then Mr. Grist on transport, and then Mr. Murray Cox on planning policy and the planning balance.
Okay, and just repeat the availability of Mrs. Brockhurst.
I think Mrs. Brockhurst needs to be away by, I think, 3 o'clock on Friday. But can I just mention, so far as the housing roundtable is concerned, we thought about this, and I think our collective view, so far as the appellants team is concerned, that we could probably get the housing roundtable session finished, and at the very least, the council's planning witnesses evidence in chief done on Thursday, which would leave my cross-examination of Spanks on Friday morning, which I would hope would still give us enough time to get through the evidence of Mrs. Brockhurst before 3 o'clock on Friday afternoon.
And would Mrs. Brockhurst have availability on Monday if that wasn't the case? Sure, on Tuesday, apologies.
So can I just, as you probably anticipate, we have a WhatsApp group that we're communicating on at the moment. I know that Mrs. Brockhurst is on the Teams meeting at the moment, so she'll have heard that question, and hopefully any moment now I'll get a response to that question. And the answer is Mrs. Brockhurst is free on Tuesday.
Thank you, Mr. Easton. Mr. Williams, I see obviously you were looking to say something. Maybe first, if you can run through the witnesses and obviously you've been instructed by and so forth, and witnesses that you're intending to call.
Absolutely, sir. Thank you very much. My name is Robert Williams of Council, and I'm instructed by Braintree District Council. Calling two witnesses, Mr. Alex Evans, who's going to be dealing with the housing supply matters and speaking at the round table, Miss Natalie Banks, who's dealing with landscape accessibility and planning matters. So I was just going to say, in relation to the proposed order, I have no particular issue in relation to the order. My only concern with Mr. Easton's suggestion is that if we do bring, I'm sorry, Miss Brockhurst, I do apologise, Miss Brockhurst forward to here on Friday, and then we don't get through her, then we'll be forced to finish at 3 when she needs to leave. Whereas if we dealt with Mr. Grist, we could certainly get through Mr. Grist's evidence, and then hear landscape Mr. Brockhurst next Tuesday, and the planning evidence as well for the appellate next Tuesday. Which it seems to me to be a more sensible. Yes, I'm getting a thumbs up. It just seems to be a more sensible order. So if we've got Mr. Grist there, and we can get the transport evidence done this week.
Okay, so Mr. Williams, just to surmise, then you're suggesting that Mr. Grist will give evidence before Mrs. Brockhurst.
Of course, it's for Mr. Easton to call it in what order he wishes.
What your view?
It would seem to be a sensible use of inquiry time, given Mr. Brockhurst is available next Tuesday, and I got the thumbs up, so I think Mr. Easton is happy with that.
So yeah, Mr. Easton, what's your view on that?
Yes, so I can give a verbal thumbs up to that. My original intention was to call Mr. Grist, then Mrs. Brockhurst, then Mr. Murray Cox. If we could have got the landscape evidence done on Friday before 3 o'clock, that would have been sensible. But now I do know that Mrs. Brockhurst is available on Tuesday. We can do landscape evidence in its entirety on Tuesday. We can call Mr. Grist on Friday, who tells me that he can do any day, so he doesn't have any availability issues. So my order, sir, as I originally intended, would be Mr. Grist, highways, Mrs. Brockhurst, landscape, Mr. Murray Cox, planning.
Okay, thank you for the confirmation. There is an attendance list circulating, so if you've not done so already, please add your name and address to it as clearly as possible, and also any qualifications you wish to be recorded. In terms of those which obviously are listening virtually, or if that is the right term, I think I suggest for today that you just email your details collectively to my case officer, so I know who virtually is, who is involved at the moment. And after today's session, shorter session, if the attendance list can return to me, please. And obviously, I'm aware that the council is screening the events. Is there any other means of filming or recording which that anyone wishes to undertake today? No. Okay. Thank you. And then in terms of the notification letters, I have a copy of those both from the council in terms of the appeal itself and also the inquiry, and also a list of those which the notification was sent to. And I've also have copies of representations that were made both to the plan application and also to the appeal as well. And obviously I'll take those into account in reaching my decision. In accordance with the Planning Inspectorate's procedural guide, I held a case management conference call with the main parties on the 22nd of September 2021. In brief, it identified the main issues, how they are to be dealt with, and the running order and timetable for the submission of the main parties' documents. The merits of the appeal were not discussed. I was asked to make a ruling at the case management conference in relation to a revised version of the site boundary plan parameter plan and concept master plan, and that was to correct a minor cartographic error in the site location boundary to exclude land under the ownership of 105 High Garrett, which I accepted. And then moving on to the proofs of evidence which I've received. I've received proofs of evidence and summaries from Matthew Grist, from the appellate side from Matthew Grist, Claire Brockhurst, Jonathan Dodd and David Murray Cox, and on the side of the council from Alexander Evans and Natalie Banks. I've read all of those proofs, so I'd expect them to be largely taken as read. So then in terms of the procedure, I shall follow the procedure set out in the 2000 inquiry rule, procedure rules. So when I've concluded my opening remarks, I will invite the appellant and the council to make a brief opening statements, and this will help everyone understand the main arguments. As obviously it's apparent there aren't interested parties here today who wish to speak, and I've been informed, I understand, there are no interested parties who have registered to speak also via the Teams link. No, thank you. As I say, that will though give Ms. Stevenson the opportunity to respond to the written representation that was submitted in lieu of a member of the public who could not attend today. After that, we will undertake the company site visits, and I'll deal with the arrangements for that at the end of the session in the inquiry room today. Then on Thursday, we will deal with a housing land supply roundtable session. That will be based on, obviously led by me, by way of the questions that I would ask as necessary, based on the agenda that I've circulated. And I'll be referring to the evidence of each main party's respective housing land supply witness, amongst other documents. We will then move on to the full presentation of evidence. The council planning witness first. The appellant's advocate will then have the opportunity to cross-examine the council's witness, and there will be an opportunity for any interested parties who are in support of the proposal, and also myself to ask questions of the council's planning witness. And that will take place before any re-examination by the council's advocate. We will then move on to the appellant's witnesses as regards accessibility to services, landscape and visual and planning, and then similarly there'll be the opportunity of the council's advocate to cross-examine the respective witnesses. There'll be an opportunity for the interested parties who object to the proposal to ask questions of each of the witnesses, as well as myself, and again that will take place before any re-examination. When all the main issues have been dealt with, I will lead on a round-table discussion on planning obligations and conditions. This is standard procedure, and it doesn't indicate that I've made up my mind on the case and does not weaken the council's continued opposition to the proposal. I'll then hear closing submissions from the council and then the appellant's advocates, and again, I'll request those submissions in writing beforehand. I'm not inviting any applications for costs, but if anyone intends to make an application for an award of cost, this should be done here before I close the inquiry. In addition, I have the power to initiate an award of costs, whether or not any applications have been made by the parties. If I were to do this, it would follow a written process with the relevant party after the appeal decision, after the inquiry is finished. Okay, that's my intended running order. I'll move on to the kind of particular days in due course, but are there any comments on that? Firstly, Mr. Williams.
No, sir.
And Mr. Easton.
No, thank you, sir.
Okay, so moving on then to the sort of a more of a day-by-day kind of breakup of how the inquiry is now to proceed. Obviously, as all parties are aware, the inquiry is scheduled for up to 6 days. I think certainly now we're moving to a virtual format, so it would be my intention to run the inquiry on the basis of around 1.5 sessions per day. And obviously, that's give or take, and obviously with inquiries, that also depends on where witnesses are in their evidence as well. But roughly, that would be, would be my intention. So there'll be short breaks in the morning and in the afternoon, and also a longer break around lunchtime. So then, in terms of today, as I say, after I've finished my opening remarks and I've heard the opening statements, we will then have an adjournment, and then the company site visit will take place. And then on Thursday, the Housing and Land Supply Roundtable session will take place. And also on Thursday, the Council's planning witness would at the very least start to give evidence. That may continue onto the Friday. I would want to ideally avoid a situation where the Council's planning witness has started cross-examination or is in the middle of cross-examination by the time we adjourn on the Thursday. So I would prefer, if it's all possible, that to take place either all on the Thursday or all on the Friday. And then on the Friday, we would also hear from the appellant's first witness in terms of accessibility. So moving on to the following Tuesday, we'd then hear from the appellant's landscape witness and also the appellant's planning witness. And then on the Wednesday, I will deal with the planning obligations, conditions, roundtable sessions, two closings, and then deal with any cost applications if any are made, and then also then we would close on the Wednesday as well. So I think obviously it's interim, and as we're aware, that can change as an inquiry progresses. But that's my initial sort of indicative programme based on what I've just heard. So on that basis, we would, I think, likely need at least part of the Wednesday. I would say. Again, Mr. Williams, have you got any comments on that?
No, sir. That sounds very sensible to me.
And Mr. Easton.
So that sounds eminently workable. I'm sure we'll all try and achieve those objectives. Thank you.
Okay, thank you. So now moving on to the plans which are before me. These are agreed in by both parties in the statements of common ground, and they are listed as the Site Boundary Plan 1001 Revision D, the Concept Master Plan 3202 Revision H, the Parameter Plan 3501 Revision B, and the Proposed Vehicular Access Plan, which is SK_001 P5. Obviously, the application itself is in outline form. Details of access are before me. Obviously, I'm aware from what I've just said, there is a concept master plan. So am I to treat this on an indicative basis? Firstly, Mr. Easton.
So that's a matter. Can I just invite Mr. Murray Cox just to address you on that whilst I get the copy of the statement of common ground available? So I think the answer to your question is yes. It's indicative rather than an approved plan, but
Mr. Murray Cox.
Yes, sir, that is correct.
Okay, thank you. Mr. Williams.
Yes, that's the way I've been treating it, and the council's been treating it.
Thank you.
I have one further point on plan, so if you're going to move on to another point.
Please, yes.
Thank you very much. Just a clarification, as I understand it, the proposed vehicle access SK001P5, I think it may be suggested that that's being replaced by revision P6, which is an appendix to Mr. Grist's proof. Because I think that responds to the fact that land to the south was refused plan permission, and it deals with that point. I'm getting nods from the other side of the table, but I just wanted to understand whether that was being suggested as an updated access. I don't think anything from our point of view turns on it, but obviously, so you'll need to know what is being proposed.
Okay, just that is actually a matter I was going to raise with Mr. Grist's evidence, but essentially it's a procedural matter. I don't mind raising that now as we're talking about the plans. Yeah, so Mr. Easton, I think if you could confirm what the status of that revision plan P6 is. As I say, the statement of common ground I have before me states P5, but as Mr. Williams has pointed out, there is a version P6 in Mr. Grist's proof of evidence.
So our suggestion to you, sir, and Mr. Williams has already alighted upon it, was that P5 anticipated that the land to the south, which has now been refused planning permission, would come forward. P6 reflects what the current position is, i.e. that the land to the south has been refused planning permission. So far as we're concerned, it doesn't alter how we would access the appeal site, but it properly reflects the up-to-date position. And so insofar as we need to make a formal application to substitute P6 for P5, I make that application now, but I don't think anything turns on it. Even if you weren't prepared to accept P6 as a replacement, P5 still identifies the way in which the site's going to be accessed.
Okay. And Ms Williams, from the Council's viewpoints, I know you've briefly touched on this, but in terms of whether or not I should accept P6, or do you have any views on that?
I haven't sought specific instructions. I have to say, on the face of it, I don't see there's going to be any particular issue. It's a relatively minor amendment to reflect the fact that the site to the south has been refused, and to provide, I understand, it's a slightly greater degree of footpath provision. I don't think the council can have concern with it, but I will take instructions and maybe confirm that when Mr Grist is giving evidence.
I was going to suggest, if any further points on this you wish me to consider, I think it's best it's raised to evidence.
Absolutely. So it was just raising it on the basis so I could understand the basis on which it's put forward, but that's helpful. Thank you.
Thank you. Okay, then in terms of sort of documents and late evidence I've received, there's two documents I want to sort of discuss really. First was the written representation from Terry Surrey on behalf of Bocking and High Garrett's Residents Action Group. And that obviously was in lieu that Mr Surrey was unable to attend the inquiry today. And I've stated already I've accepted that representation on that basis, but I will give Mr Easton the opportunity to respond to that later this morning. Now, the second document I received was from the council, which was late last Friday, and that was a response. It's a response and an update to the Station Road appeal decision, which the appellant drew my attention to, which I believe was last week as well. I think, Mr Williams, firstly it'd be useful for me to explain why you consider the council's document or response is of relevance.
Yes, thank you very much, sir. As you say, the Station Road appeal decision was handed down, promulgated on the 12th of November, so less than two weeks ago. And actually, we drew it to the appellant's attention as being plainly relevant to the matters in discussion, because that inspector, following a hearing, who concluded there was a 4.7 to 4.9 year supply of housing, and obviously 5-year housing supply is a matter in dispute here. And all parties agree that decision is relevant as material consideration here. The note responds to the inspector's conclusions in relation to Station Road in two ways. First of all, it produces a narrative of the council's response to the Station Road decision, and it was produced at my request so that you, sir, and the appellant has some advance warning of what the council were going to be saying. Well, first of all, what its position was, but secondly, what the council was going to be saying in relation to the sites that the inspector there discounted, so that it wasn't heard for the first time during a housing land supply roundtable, so that there was a degree of forewarning. So that was the intention. And secondly, it contains a number of appendices, some of which, at least, include evidence which has only been available to the council last week. And if I could just briefly run through those. So there's a note on its face which explains what Mr Evans will be saying, which he can expand upon as a round table, but to give advance warning. But then the appendices, there's Appendix 1, which is a note that's gone up on the on the council's website to clarify the public to the council's position following the Station Road decision. Secondly, there is an updated pro forma in relation to one of the sites, Broad Road, East Broad Road. That was received on the 17th of November last week, and was sought because the inspection of Station Road pointed out that the pro forma that previously been provided was being provided by an agent, and now we've received the pro forma from L&Q themselves. And obviously the PPG requires that up-to-date evidence be taken into account. The third appendices is a phasing plan and strategy for the same site, Broad Road. That was in existence before. That's been in existence since August of this year. But the reason it became relevant is because the Station Road inspector said she didn't have any evidence as to the infrastructure requirements of the site, and that does give evidence as to the infrastructure requirements of the site and what can be built and what can be occupied prior to that infrastructure coming forwards. The fourth appendices is a further pro forma in relation to a separate site, Long Green, and that was received last week on the 18th, so again, up-to-date information. And then the fifth appendices is an updated Scott schedule. So you've received a Scott schedule from the parties setting out their different positions in relation to the disputed site, whereby the council has reduced its trajectory over the 5-year period by 50 homes to reflect the latest available evidence from L&Q in respect of the Broad Road. So it's to provide an update and in essence in the appellant's favour. So in all, so we did do it in a way that was attempt to be transparent, put forward the council's case in advance of the housing land table, and to draw your attention, sir, to the most up-to-date information, which is of course what you've got to determine the position on. The note itself also draws attention, as had already been drawn in Mr. Evans's evidence, to the fact that matters have moved on in a number of regards from the Station Road decision, but we can get into that when we get to the Station Road. So for those reasons, sir, and given the appellant will have had some time to consider it, I do request you accept the document and render it admissible.
Mr. Easton, do you have any views in relation to whether you consider I should accept the evidence?
Yeah, so I do. My general position is to resist the introduction of late evidence. However, I suspect what would have happened if this document hadn't come in would be the council would attempt to introduce this evidence during the round table session, at least orally. So to that extent, it provided us with some indication about what the council is likely to say in response to the Station Road appeal decision. And of course, they must be entitled to provide their views about whether they accept that or not. And so we'll get into some detail about the relevance and the weight you attach to the Station Road appeal decision in due course. So reluctantly, sir, given its timing, we don't object to its introduction. But can I just add this note of caution? I would seek the council's assurance that no further evidence in relation to housing land supply in particular is sought to be introduced before or even during the housing roundtable session, because that would be too late.
Mr. Williams.
Certainly, I don't envisage anything, sir. There's nothing in the pipeline, as I've conferred to my learned friend.
Okay. Just a point of clarification. Obviously, now I have two Scott schedules before me. I appreciate, obviously, I'm aware of the differences between the two. I think when we get to the session in terms of housing land supply, I'll be interested in parties' views in terms of which Scott schedule that I should give consideration to during that session. Obviously, I'm aware that, as far as I'm aware, the only change is the council has updated, I think, one figure in that schedule. But I'll need to take views on that. But I think I'm best on doing that in terms of when we start the housing land supply session.
Absolutely, sir.
Yeah. Okay. Obviously, all documents and evidence should have been provided, and I think on that basis I will accept that document, and I'll call that inquiry document 1.
Thank you very much, sir. Thank you very much, sir. That's very helpful.
As I say, all documents should have now been provided. However, if there's any intention of any further, please tell me now, Mr. Williams.
There isn't nothing further. Just to clarify, there was a note from Emma Goodings, head of planning, last week about the local plan progress, which you should have seen, so which the appellants have not resisted, and that's gone in as a core document. I understand, so that that we're dealing with on the basis that's accepted in as evidence.
I did. I asked essentially what I've said on that point is the essentially both main parties to agree the core document list between them. I understand that's not an issue. Mr. Easton, is that your understanding as well?
It is my understanding, sir. Just whilst I've got the floor, as it were, can I just rewind a little bit to the letter from Mr. Surrey? You did say you give me an opportunity to respond to it. I can do it.
Essentially, I've got no problem with you doing it now, Mr. Easton. I was just going to finish my opening comments. I was going to actually do it after we'd done the you've done the opening. The opening
Fine.
statements.
Well, I was going to be very brief and simply say we don't have any objection to it, and to the extent we need to respond to any of the substance of the letter, we'll do that in evidence.
Okay. Thank you for the clarification. And Mr. Easton, is there any further documents or evidence that you intend to submit?
No, sir.
Thank you. And obviously, as no doubt both main parties will be aware, only exceptionally will material received after the close of the inquiry be taken into account. Okay, moving on to the main issues then. The main issues as I see them are whether the proposal would be in a suitable location for housing with regard to development plan policy and national planning policy, the accessibility to local services, the effects on the character and appearance of the area, housing and supply matters, and planning balance, including the benefits of the scheme and the conclusion. Mr. Williams, any comments to make on those main issues?
No, so they're very helpfully set out in the CMC note. Thank you for that.
And Mr. Easton?
No, sir, and as you'll see in my opening submissions, I follow that framework. So thank you.
Okay, well that concludes my opening remarks. Are there any other queries at this stage in relation to essentially procedural matters before we move on? Mr. Williams and Mr. Easton.
No, sir.
Okay, thank you. Okay, Mr. Easton, will you please make your opening statements?
I will say, if Mr. Murray Cox could hand you, I hope, a hard copy, and hopefully hard copies certainly to Mr. Williams.
Thank you.
Thank you, Mr. Murray Cox.
Okay. I'll call this inquiry document 2. Okay, please proceed.
Thank you, sir. You'll see on the first page is a notice of appearances with the relevant qualifications and experience in areas which individual witnesses are going to be covering, just for your notes, sir. But I'm going to go straight into the text on page 2. The local planning authority refused planning permission for 2 reasons. We say the second reason for refusal is overcome entirely through the imposition of conditions and or the execution of a Section 106 agreement. The remaining issues arise out of reason for refusal 1 and are neatly encapsulated in your post-conference notes there, and you've repeated them a few moments ago. I don't propose to read them out. It's safe to note that I'm going to set out the appellant's position in respect of each of those issues in my opening. Firstly, suitable location for housing. There's no argument from the appellant that the adopted development plan represents the starting point for you, sir. In this context, the most recently adopted part of the development plan, the Local Plan Strategy Part 1, expressly envisages development within and adjoining settlements. The flexibility inherent in Local Plan Strategy 1 doesn't give free rein to all proposals outside settlement boundaries. We don't say that it does. Rather, it suggests a nuanced approach that examines the site-specific impacts of the appeal scheme. But Policy SP3 does not allow the local planning authority, as here, to set up an in-principle objection merely because the appeal site falls outside the settlement boundary. Such an approach would run contrary to national policy, which doesn't give the same level of protection to all areas of land outside settlement boundaries, irrespective of their sensitivity or their value. The appeal scheme does, we accept, run contrary to the extremely elderly policy RLP2 of the local plan review and the core strategy policy CS5 by virtue of its location outside settlement boundaries. These policies pull in the opposite direction to policy SP3 of the local plan strategy 1, with the most recently adopted policy, we say, taking precedence. Taken together, these restrictive policies form the most important policies for determining the appeal and are out of date. The boundaries that these policies seek to protect were fixed long before the National Planning Policy Framework and well in advance of the Council setting an objective housing need figure for the area. They seek to protect, in other words, not harm, all land outside settlement boundaries, irrespective of its quality, an approach which is contrary to the framework's more sophisticated policies. These conclusions provide a further basis, irrespective of whether a 5-year housing land supply exists, for tilting the planning balance in favour of the appeal scheme. In any event, a breach of these policies should attract only limited weight given the lack of a 5-year housing land supply, the fact that the current boundaries don't reflect current housing need, and the Council's reliance upon housing sites which sit outside existing settlement limits. Indeed, the clear inference is the Council itself recognises that these boundaries and the policies that protect them are no longer fit for purpose. So it's, in this context and under this topic, our primary case is that the appeal scheme complies with the development plan taken as a whole. Planning permission, as national policy indicates, should therefore be granted without delay. Nonetheless, if there is a conflict, that is far from the end of the matter. The main parties agree that the National Planning Policy Framework is a material consideration of substantial weight. NPPF policies are more than capable of outweighing any conflict with the development plan, and this is just such a case. Both national and local policy encourage the siting of residential development in locations that avoid harm to areas or assets of particular importance, which are accessible to sustainable modes of transport, and which are able to deliver net gains in environmental, social and economic terms. The appeal scheme unequivocally satisfies these objectives. It is a suitable location for residential development. I'll turn to the second issue, accessibility to local services. At its heart, the aim of national transport policy is to reduce the negative environmental and public health effects of travel. Through the scheme travel plan, residents will be encouraged to use sustainable travel modes by providing fibre optic broadband. Home working, which is now embedded in many of our lives, will be made easier. National policy does not demonise the private car. On the contrary, car sharing and low or zero emission vehicles are expressly included within the definition of sustainable transport modes. The appeal scheme will facilitate and support these modes. These measures will deliver the national policy objective before one even considers walking and cycling distances or the proximity of buses and the frequency of services. It's important to note, sir, that in national policy terms, the NPPF speaks of providing, I quote, a genuine choice of transport modes and maximising sustainable transport solutions. These are the requirements, not a requirement to limit car use to an absolute minimum or eliminate it altogether. The appeal site is a sustainable location in these terms. Indeed, the local planning authority has already recognised that High Garrett is a relatively sustainable location in granting planning permission for 3 other schemes. As to the detail of distances to specific services and the quality of the links, those are questions to be explored in evidence, but the following conclusion will be unavoidable, we say. The appeal scheme will offer walking, cycling for confident cyclists, bus, rail and electric cars as realistic sustainable travel options for residents, such that residents will not be reliant upon the private motor car. Issue C, character and appearance. The question of landscape value, sensitivity and the effects of development will be addressed through written and oral evidence, and you'll get a clear impression, sir, on your site visit later on today. In opening, we would simply stress the following points. Firstly, the Council's landscape services raised no objections to the appeal scheme and no landscape expert is being called on behalf of the local planning authority. Secondly, the landscape and visual appraisal supporting the appeal scheme has not drawn any adverse comment from the local planning authority. Thirdly, the Council's independently prepared evidence base for the local plan concluded that the appeal site possesses a medium landscape capacity for development and would form, I quote, a natural extension to High Garrett. and that sloping topography provides separation between the appeal site and the farmland which adjoins it. There is absolutely no objectively prepared evidence which justifies identifying the site as a gap which prevents the coalescence of settlements. Next, some adverse effect on landscape character would arise from the appeal scheme. However, in drafting national policy, the government must have anticipated that a certain level of harm to landscape character would have to be accepted in order to meet society's wider and pressing need for housing. This is especially the case where the tilted balance applies. In other words, there's an added imperative to deliver housing. Fifth, the appeal site isn't designated for its landscape value or for any other purpose. Next, the appeal site is ordinary countryside on the edge of the built-up area, which already has an appreciable effect on its character. It does not possess any demonstrable physical attributes which elevate it beyond mere countryside. And finally, the appeal scheme provides important opportunities to strengthen and manage its positive attributes, which opportunities would not exist if the appeal is dismissed. Overall, we say it will be apparent from the evidence and from your site visit, sir, that any landscape or visual harm does not approach the threshold of unacceptability. As such, a key plank of the Council's case is without foundation. So, penultimately, housing land supply. It's important to observe that the Council's housing supply position has consistently been fragile, and where it has exceeded 5 years, any excess has been extremely marginal. It's therefore unsurprising that less than 2 weeks ago, an inspector examining substantially the same evidence base as at this inquiry concluded that the Council's housing land supply ranged between 4.7 to 4.9 years, sufficient on either basis to tilt the planning balance. That decision, as we note Station Road, is an important material consideration that we recommend you follow, sir. So far as the detail, there is complete agreement as to the housing requirement. The question here is whether the Council can demonstrate a deliverable supply, in particular whether it can provide clear evidence for those sites where there is not a presumption of deliverability. Interestingly, since the proofs were exchanged, the local planning authority have reduced their surplus from 371 to 336 and now to 286. A clear downward trend, we say. It is this claimed surplus that should be the focus of discussion, for if you conclude, sir, that the appellant's judgment is to be preferred in respect of 286 dwellings, there will not be a 5-year housing land supply. It is equally notable that a significant proportion of the Council's claimed supply arises from planning permissions granted on appeal. If I turn to the final issue, sir, the planning balance, including the benefits. Development of the appeal site would bring substantial and compelling benefits, including the provision of up to 37 homes in an area where the Council has consistently been unable to demonstrate a 5-year supply of housing, delivery of 40% affordable homes. This is to be set against the context of a local authority which have accumulated a large shortfall in affordable housing. Substantial weight, we say, should be attached to this benefit. The introduction of an economically active population and the creation of additional jobs, representing an important boost to the local economy. These economic benefits, which don't appear to have been challenged by the Council, should weigh heavily in favour of the appeal scheme, especially when the Council is not delivering the level of economic growth that should go hand in hand with a deliverable supply of housing. Next, the provision of bus stop upgrades, pedestrian crossings and a footway for the benefit of future and existing residents of High Garrett. The provision of open space and the enhancement of existing recreational provision, the delivery of net biodiversity gains, and a series of landscape benefits, including long-term management, the enhancement and management of existing hedgerows and trees, and the creation of new linear green infrastructure. Taken in the round, the appeal scheme will undoubtedly produce net positives in respect of the social, economic and environmental aspects of sustainable development. To that end, it aligns itself closely with one of the most fundamental objectives of national policy. Even if the appeal scheme runs contrary to a number of development plan policies, any such conflict should be afforded limited weight in light of the fact that the district settlement boundaries are not fit for purpose. The considerable benefits of the proposal seen in light of the government's critical objective of addressing the current housing crisis substantially outweigh any negative impacts. whether the tilted balance applies, or, contrary to our case, sir, that the scales are evenly weighted, the positive effects of this appeal scheme far outweigh the very limited harm. And so it's for all of these reasons that we anticipate in due course being able to invite you to grant planning permission, subject to conditions and an executed planning obligation. Thank you very much indeed, sir.
Thank you, Mr. Easton. Mr. Williams?
Thank you, sir. I've got hard copies for those in the room. I've only got two sets. Could you give one to the opponents? And I will try and send right now, Mr. Easton, a electronic copy.
Thank you, Mr. Williams.
I'll call this Inquiry Document 3.
Thank you, sir. That has gone. Are you happy to start, sir?
Yes, please proceed.
Thanks, sir. As I said, start this appeal concerns a proposal for 37 dwellings on land rear of 105 High Garrett, Braintree, with all matters being reserved except for access. And like Mr. Easton, I set out the main issues, which are consistent with those that you identified in the CMC note, and I structure my opening around those main issues. First of all, suitable location for housing. A residential development of the appeal site is contrary to the spatial policy of the existing and emerging development plan policy. The conflict operates at two levels. Firstly, the appeal site lies outside the settlement boundaries in the countryside. Existing development plan policy directs new development, except that which is appropriate to the countryside, to areas within settlement boundaries. The emerging Section 2 local plan takes the same approach, confining development outside the settlement boundaries to uses appropriate to the countryside. It's understood to be common ground that this proposal is contrary to those policies. As part of the evidence base for the Section 2 plan, the settlement boundaries were reviewed and amended to ensure they accommodate housing needs until the end of the plan period. That's 2023, sir. The policy approach, together with the evidence underpinning the settlement boundaries and the ability to meet housing needs, was tested at recent local plan examination in July of this year. It is of some note, therefore, that the inspectors examining the Section 2 plan have recently approved main modifications of the Section 2 local plan at full consultation, none of which casts any doubt on the ability of the Section 2 plan to meet its needs, the soundness of the settlement boundary policy, or for the purpose of this appeal, at least, which make any material changes to the settlement boundaries in the emerging plan. In short, the appeal site falls outside of the emerging settlement boundaries in the countryside. Now, contrary to the appellant's case, properly understood, policy SP3 of the Section 1 local plan is not in tension with the settlement boundaries policies, including LPP1. The Section 1 local plan is concerned with strategic matters that have cross-boundary impacts across the three North Essex authorities, Colchester, Tendring and Braintree, and it provides a vision for how planned growth, including for housing, will be realised. Policy SP3 therefore establishes the framework for the spatial strategies and allocations in the individual authorities' Section 2 plans. It is the allocations and policies of the individual Section 2 plans which realise the requirements of Policy SP3, including the objective to accommodate development within or adjoining settlements according to their scale, sustainability and existing role. And it is the policies of the Section 2 local plan, and not Policy SP3, which are directly applicable to the proposals for unplanned, non-strategic housing growth, such as the current proposal. Secondly, sir, as Policy SP3 itself explains, in Section 2 of the local plan, each local planning authority will identify a hierarchy of settlements where new development will be accommodated according to the role of the settlement, sustainability, its physical capacity and local needs. The emerging Section 2 local plan does exactly this, identifying, through the proposed main modifications, which I say have been approved by the inspectors for consultation, High Garrett as a third-tier village, namely those which lack most of the facilities required to meet day-to-day needs, and where, even within the settlement boundaries, the tests of sustainable development will not normally be met. It's wholly unsurprising, therefore, that the spatial strategy of the Section 2 plan does not seek to concentrate development, or at least any significant development, within High Garrett. Accordingly, residential development in this location is not only contrary to the settlement boundary policies of the existing and emerging local plans, it's also contrary to the spatial strategy of the area. Thus, application of development plan policy is unequivocal. This is, as a matter of principle, an unsuitable location for housing. As the next main issue illustrates, the application of national policy also identifies the appeal site as an unsuitable location for housing, and that is a matter of accessibility. Now, national policy requires that significant development should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes. As is evident from the categorisation as a third-tier village, there are virtually no facilities in High Garrett which would enable future residents of this site to meet their day-to-day needs. The closest settlement with any range of facilities for meeting such needs is Bocking, and even it does not have a full range of facilities. It is lacking, for instance, a secondary school, GP or post office. However, the appeal site is not within reasonable walking distance of Bocking. Only 2 months ago, an inspector dismissing an appeal concerning the site immediately to the south concluded that the walking distance from the site to facilities and services in Bocking would be prohibitive. And it's not only distance which would deter future residents from walking. The most direct route is especially unattractive for walkers, involving not only walking next to the busy A131 for much of the route, but also having to cross it on a number of occasions. The quantum of traffic using the A31, the nature of that traffic, and the speed of the traffic would act as a severe deterrent to cyclists, with even Mr. Grist recognising that only confident adult cyclists may choose to travel by this mode. In reality, very few of the future residents would be likely to cycle, at least on any regular basis. It's recognised that the bus service is reasonably good, albeit the need to cross the A131 to travel south towards Braintree would act as a disincentive to some. However, that does not come close to outweighing the lack of accessibility by foot or cycle. The Thistle Field Inspector was therefore right to find that occupants of the proposed housing would be primarily reliant on private transport, and that the location has substandard access to local services and facilities. It is, in truth, a wholly unsustainable location for significant development. Turning to the effect and character and appearance of the area, the appeal site is, and is perceived to be, a part of the countryside. Together with Thistlefield immediately to the south, the agricultural undeveloped nature of the appeal site provides a relief to the continuous ribbon development on the eastern side of the A131. This relief from built development provides both a degree of visual separation, at least on the western side of the A131, between High Garrett and Bocking, and contributes to the rural setting of High Garrett itself. Moreover, given the importance of the A131 as an arterial route into and out of Braintree, the character of High Garrett and its immediate surroundings, which include the appeal site, contributes to the gradual transition from countryside to the town and vice versa. The importance of retaining undeveloped areas on the western side of the A131 was recognised by the inspector in the Church Street decision, who found the development of parcel of land at the Church Street A131 junction would be visually harmful and refused permission for the large scheme which would develop this area. The proposals would eradicate the countryside character of the appeal site, replacing it with an urban or suburban character. This would be visually harmful because the rural and verdant appearance of the western side of the A131 in this location would be partially eroded, and in terms of landscape and townscape of High Garrett, by reducing its separate identity and its rural setting. Turning then to housing land supply. Notwithstanding the findings in the recent Station Road decision, where the inspector found the supply was just under 5 years, the Council is confident it can demonstrate a 5-year supply of housing. It considered that the Spectre, in that case, took an inappropriately strict approach to the question of whether there was a realistic prospect of housing being delivered within 5 years, ignoring the fact that, as the courts have emphasised, this requires neither certainty nor even probability of delivery. In any event, since that hearing, matters have moved on in relation to a number of disputed sites. Furthermore, it must be remembered that the Council have taken a conservative approach to assessing 5-year housing land supply, in particular by not including or not seeking to include any of the emerging allocations in the Section 2 local plan which do not already benefit from a grant of planning permission. Turning then finally to the planning balance. The proposal is undoubtedly in conflict with both existing and emerging development plan policy, not only because of the breach of the settlement boundary policies and the conflict with spatial strategy, but also because of the breaches of policy consequent on the lack of accessibility and harm to visual amenity and landscape character. It's also contrary to national policy in this regard. It's acknowledged there are benefits from the appeal scheme, chief amongst them the delivery of market and affordable housing, albeit this is tempered to some degree by the housing land supply position. The Council considers the benefits of the proposal do not justify a departure from the development plan, and this is so even if the tilted balance is engaged. The adverse impacts of the scheme significantly demonstrably outweigh its benefits. For all these reasons, which will be more fully addressed in the Council's evidence and articulated in its closing submissions, the Council will invite you, sir, to refuse planning permission and to dismiss the appeal.
Thank you, Mr. Williams. I'll now move on to the site visit arrangements. Obviously, I need to access the site with both parties in attendance, and as I mentioned earlier, you'll be able to point out physical features in a matter-of-fact fashion, but I will not entertain points related to promoting the respective parties' cases. So firstly, who will attend? Firstly, for the appellants.
I will, sir. David Murray Cox, Turley.
And for the council?
Miss Banks will attend, sir.
And are there any health and safety issues that I need to be aware of on site? Okay. What I'm going to suggest we meet is where the public right-of-way leads into the site. What I'm going to suggest that we meet in terms of on the site visit is where the public right-of-way at that point. If we meet at that point, then we can go into the site. And I suggest we meet there at 11:30. Sorry, is that? No, sorry, it's at 12:30. Apologies, I'm just reading the kind of clock slightly wrong. It's at 12:30. I also intend, obviously, doing an unaccompanied site visit in terms of the broader area, and I obviously asked that's at the case managing conference, and I think what correspondence I received that was from the appellant in terms of the viewpoints in the landscape LVIA documents, and obviously I intend doing that. Mr. Williams, do you know?
Yes, sir. Well, if you are taking unaccompanied, we would also request that you certainly at least walk down the A131 to Church Street. And if you have time, sir, to walk to the blocking, given the accessibility issues, obviously leave that for matters to you as to how far you need to go.
Okay, thank you. Okay, well, I think this is a suitable point to adjourn the inquiry. As I say, we'll meet on site on 12:30, and then on Thursday we'll resume at 9:30. Could the attendance sheet please be passed back to me before I leave today? Thank you. And just in terms of this document's put in my desk, Mr. Eaton, I don't know whether you can see or not, but essentially what was put in my desk was from the council was basically, I think, a repeat document in terms of the notification for the inquiry when we were talking about whether we should proceed on a virtual or face-to-face basis. Now, I've already got this document, to be honest, so can you, I don't need it, so, yeah.
So, sometimes inspectors ask for hard copies, or they at least used to, of the, but you've seen it before.
I've got a copy of the documents ready, yeah, thank you. Okay, well, the time is now 11:14, so we'll adjourn to the site visit at 12:30, or otherwise we will resume on Thursday at 9:30 on a virtual basis. Thank you.
Thank you very much, sir.